The Supreme Court, as presently constituted under Justice Mohammed Tanko, has become heavily compromised, lost its credibility, and now annexed to execute ignorable agenda of the APC-led federal government against the people of Nigeria.
PDP is not only reckless, they believe it is their birthright to continue to benefit from electoral fraud and electoral manipulation.
Does the Supreme Court have powers to formulate and allocate votes as election results?
Courts are bound to interpret law according to the Constitution, whereas the courts can bend laws or nullify laws to the extent that they are inconsistent.
Judgment of the Supreme Court voiding the lawful election of Honorable Emeka Ihedioha, who scored 276,404 and awarding fictitious votes to declare Hope Uzodinma of the APC, who scored 96,458 as a governor of Imo State, is highly irrational.
Even at the time Ihedioha was declared the governor, no attempt was made to disguise the fact that he did not score 1/4 of the vote cast in 2/3 of the local governments in Imo State. As far as we know, Imo has 27 local government areas, and Emeka Ihedioha scored 2/3 of the vote in only 12 local governments. 2/3 of 27 is 18. So you have a huge deficit of 6 local government areas, which Ihedioha or any other person must necessarily have to be able to be declared as the winner of a governorship election.
With the verdict of the Supreme Court executed, a coup against the PDP and the people of Imo State, as well as other Nigerians, and as such must not be allowed to have a place in our democracy.
It has been the philosophy of PDP, particularly from 2003, after the 1999 election, to arrogantly ask their agents or activists and manipulate INEC to ask them to declare results of election and arrogantly tell the winner who would have been declared the loser to go to court and challenge the result if he's not ready to accept the fraud perpetrated usually between INEC and PDP. That was exactly what they did in the case of Imo.
Did Hope Uzodinma call the 388 witnesses from the 388 polling units to speak to the result to obviate the principle of dumping which the Supreme Court had used against the PDP?
The collating officer, a professor of mathematics, curiously did not know that 12 is not 2/3 of 27 local government areas. He proceeded recklessly to unlawfully declare Emeka Ihedioha as the governor of Imo State. In a society that is committed to truth, fairness, and rule of law, that returning officer ought not only to be dismissed, he ought to be helping himself with security agencies as to how he arrived at the decision to declare Emeka Ihedioha as winner. I believe, in the light of the findings of the Supreme Court, there must be consequential actions. That now that it has been established that the professor went out of bound of reason and indulged in this reckless pronouncement that has led us to this situation that we are in, he cannot be enjoyed the comfort of his home while he accepts to create or lay foundation that all kinds of political vultures are trying to feast on.
What are the figures from each of these various 388 polling units generated and allocated to Hope Uzodinma APC by the Supreme Court.
In each of these 388 units, INEC appointed unit presiding officers signed those results. The party agents in these 388 units signed those results. So the validity of the votes in these units were never in dispute. INEC did not have any cause and indeed did not cancel these unit results. All that happened is that the collating officers, for reasons best known to them, refused to collate the result from 388 units in the governorship election that were in favor of Senator Hope Uzodinma.
Is the Supreme Court saying that all the votes from the alleged 388 polling units were for the APC alone in an election that was contested by over 70 candidates?
There is usually, for the average politician, your own base is usually where you have the strongest support. Senator Hope is from the Olu senatorial zone, and it is the votes in these units that were not counted or collated for him, and they were never cancelled. So it was clear to us that even the first election petition tribunal, on the basis of this fact, would have no difficulties, first in nullifying Emeka's purported declaration as a governor because he didn't have the spread. This is a constitutional provision for which the court has no discretion.
The tribunal or court of appeal did not mention or ascribe any figure from the unit to any party in their decisions. In fact, in the cross-examination of the APC candidate, Senator Hope Uzodinma, he could not read any figure from the Oluwale results. He said that the figures were not clear.
The Supreme Court nullified the election of Ihedioha on the ground that the result before them shows clearly that he did not win the 1/4 of the lawful vote cast in at least 2/3 of the local government in Imo State. That pronouncement of the Supreme Court already take out Emeka Ihedioha as a valid, already settled the issue of his governorship. The worst that could have happened if there were no other issues is that once the governor, Emeka, was out, the other possibility was whether or not a rerun was required or a repeat of the exercise.
The so-called results from the 388 polling units were rightfully rejected in line with several decisions of the Supreme Court.
There is no question that the votes in 388 units validly cast, signed by unit presiding officers, signed by party agents, were not collated by the collating officers. We had expected that the tribunal would naturally take this into account and Hope Uzodinma would be declared. Because once you add the result from 388 units to the ones already accredited to Hope Uzodinma, he would have been the highest, he would have scored the highest number of votes ahead of all the other candidates. But by simply not counting these votes, that is why some people who are not informed keep insisting that the man INEC declared as last, as fourth, how could he come first?
In order to avoid an imminent breakdown of law and order, which we seek, the PDP demands that Justice Tanko Mohammed immediately stepped down as CGN and chairman of the National Judicial Council, as Nigerians have lost confidence in him and a Supreme Court under his leadership.
If we only celebrate when we win, denounce, abuse, and demand removal when we lose, there will be no judiciary in Nigeria. PDP leaders are being short-sighted when they frontally attack the judiciary each time they lose election. And when they win, however unfairly in the eyes of ordinary people, is democracy at work? The rule of law has prevailed. Review the comments credited to PDP in all those states where they were declared winners. You will find them celebrating the judiciary to high heavens. But review their comment where APC has won. You will never see any one of them in which they admitted that the rule of law has prevailed. This is a very, very dangerous attitude.
The Supreme Court, as presently constituted under Justice Tanko, has lost its credibility and no longer commands the respect and confidence of Nigerians.
We repose confidence in the Supreme Court, not just among the judges that sat on this panel, but on all the judges that are in the Supreme Court.